Day 30. Dirty 30, so they say. Anyway, welcome, day 30. You've made it this far. It's about exit positioning. It's the final one. How to leave family court without being permanently defined by it. Day 30. This is the part nobody prepares you for. Not the hearing, not the allegations, not Kafkas, not cross-examination, not the judge with the emotional range of a parking meter, not this is the part they don't warn you about. This is what happens after. Because family court doesn't just decide arrangements, it labels people. And that label doesn't just sit inside the case file. It follows you into the next hearing, the next report, the next social worker, the next school narrative, the next safeguarding concern, the next concerns email, the next parent's solicitor's letter. So today, it's about one thing: exit positioning. How to leave the process in a way that doesn't leave you wearing the professional tag like a scarlet letter. The brutal truth about the win. Most parents think the win is more time, a better schedule, a finding, a dismissal, an order that finally forces compliance. But what I want you to understand is this: you can win an order and still lose the war, because you exit with the wrong identity attached to you and you leave as high conflict, lacking insight, doesn't prioritize the child, fixated, rigid, controlling, emotionally dysregulated, poor boundaries. And once that identity exists in official language, it becomes self-reinforcing. Professionals don't read your whole case. They read the label. Then they treat you like the label. Then your reactions become evidence of the label. Then you spend years fighting the label instead of pretending parenting your child. That's what we are preventing today. Family court's final move, narrative lock-in. Here's the trade secret. At the end of proceedings, the system is not only deciding the order, it's deciding the story it can safely file away. Judges in Kafkas aren't thinking who's right. They're thinking, what explanation makes this outcome defensible if someone complains later? That's why judgments and reports lean heavily on phrases like in the child's best interest, risk management, stability, settled arrangements, need to reduce conflict, proportionality, safeguarding reassurance. These aren't just words, they're legal insulation, and you need to leave the case aligned with those words. And you do that without surrendering your reality. The exit question you must ask yourself, day 30, has one governing question. What will they say about me when I'm not in the room? Not what you say, not what your solicitor says, not what you feel, what the system will write as your identity when it closes the file, because that identity becomes your starting point next time. The 3 exits, pick the right one. There are 3 ways people exit family court. Exit 1, the explosive exit. They lose patience. They go nuclear at the wrong target. They tell the judge off. They accuse Kafkas. They call everyone corrupt. They tighten the press. They threaten with the press. They write 14-page emails, and then the file closes with emotionally dysregulated, high conflict fixation. Congratulations, you just handed the system a reason to justify everything it did. Exit 2, the silent exit. They get exhausted. They comply. They disappear. They accept whatever interim became final. They stop challenging breaches. They stop pushing review points. Their file closes with arrangements appear settled, no further concerns. This is the most dangerous exit because it quietly endorses the status quo. Exit 3, the operator exit. This is what you're learning. You don't explode. You don't vanish. You position. You leave the file saying child-focused, solution-led, proportional, stable, seeking relationship repair, willing to work with professionals, calm in tone, firm in trajectory, and crucially, you leave a re-entry route, a way back into court later without being framed as the problem. This is the exit that protects your future. What operator exit positioning actually looks like. This is where I'm going to get painfully practical. If you want to exit well, you need 4 things on the record. A child-centered intention statement. Short, boring, unstoppable. Not emotional, not dramatic. Something like, my focus is for the child to have a stable, safe, meaningful relationship with both parents. I will comply with the order and remain child-focused. I seek that the arrangements be kept under review to support progression where appropriate. This is not weakness. This is identity engineering. You're planting an official version of you that future professionals will read first. Number 2, a progress mechanism. Review triggers, steps. In that order, if the order is restrictive, you must avoid open-ended limbo. You want review hearing date or a step plan or defined triggers for progression, clear expectations around compliance. And why? Because without progress, without a progress mechanism, temporary becomes permanent, and courts hate reopening settled cases unless you give them a safe reason. Number 3, a compliance trail. You do what you say. You don't exit on promises, you exit on documented behavior, compliance with directions, calm communications, reasonable proposals, consistent attendance, no sabotage. The system trusts what it can describe. Give it something to describable. Number 4, a clean re-entry narrative. If things go wrong, this is the real operator move. You leave the case not as I'll be back to fight you, but as if progression doesn't occur, or if orders are breached, I will seek the court's assistance in a measured way, focus on the child's welfare. That sounds harmless. It is not harmless. It is future leverage because it frames any future application as necessary and child-led, not conflict-driven. The moment everyone gets wrong, closing submissions, final words. Most people at the end go emotional. They do the big speech. They try to be heard. They dump pain on the bench. I understand it, but I'm telling you the truth. Family court punishes emotional dumping at the end because it reads it as instability. Your job at the end is not catharsis. It is to deliver final identity. This is what your final words should look like or should do. It should confirm compliance. It should be child-focused, confirm child-focused, request progression mechanism, request clarity on any ambiguity, avoid blaming, avoid moral judgment, avoid insults, avoid you harming my child language. You can think it by all means, but don't say it. You can write it in a diary, but don't say it. But you do not gift the system a sentence that it can weaponize. The harsh reality, you may not get the order you deserve. I'm not going to lie to you. Some people will do everything right and still exit with a restrictive order because risk systems can be cowardly. They can choose safety, theater over reality. But you're not just trying to win the present. You're trying to win the next chapter. And that's really important. You've always got to be looking future, not living in the future, but looking at the future. And that's why Day 30 matters, because the parent who exits stable and safe has a future. The parent who exits as high conflict gets trapped. The operator's rule for the rest of your life. Here it is. Write it down, write it on your forehead, stamp it in your brain, whatever you need to do. Never become the story they need. If they need a villain to justify delay, don't be it. If they need conflict, if they need a conflict parent to justify restrictions, don't be it. If they need a fixated litigant to justify ignoring evidence, don't be it. Stay calm, stay boring, stay structured, stay inevitable. That is power in this system. Now look, final practice task for you. This is your final training task. It's simple, it's brutal, it works. Write your operator exit statement, 1 page maximum. Write 4 short sections. Firstly, identity, 2 or 3 sentences. Who are you in this case? In official language. B, child focus. 2 or 3 sentences. What outcome do you want framed around the child? Progress mechanism, bullet points. What needs to happen next for progression or stability? D, re-entry route, 2 or 3 sentences. If things don't progress the way they're supposed to and orders are breached, what is the measured next step? Now, with this in mind, you cannot have no blame. The rules are no blame, no drama, no moral argument. Make it sound like someone a judge feels safe endorsing. If you can do that, you have just done something most litigants never learn. You have built a future version of yourself inside the file. Now, that's day 30. Court Ready was never about turning you into a lawyer. It was about turning you into someone who can walk into a risk system and not get crushed by it. Most people will leave family court defeated, not because they lost the case, but because they left. You now know how to avoid that. And if you can exit clean, you can return strong. That's the difference between a parent who gets evased and a parent who stays in the child's life for the long game. And what comes after Court Ready in 30 days? Well, Court Ready in 30 days was never meant to be an end of anything. It was meant to get you out of danger. Most people arrive in family court panicking. They don't understand the system. They react emotionally. They make mistakes. that get written onto the file permanently. This program was about stabilization, stopping you from self-sabotage, teaching you how the system actually thinks, getting you through hearings without becoming the problem. But here's the uncomfortable truth. Once you're stable, the real game begins. And that's the part nobody teaches. The next phase of training is not about forms and templates. It's about operating inside a system long-term, because most parents don't lose their children in one hearing. They lose them slowly, through delay, through narrative drift, through professional shorthand, through temporary becoming permanent, through silence being interpreted as consent. The next training is about what happens after you stop panicking. The next program is about the things professionals never say out loud. We'll be covering things like how cases quietly harden between hearings, how professionals decide who is safe and who is difficult, how to re-enter court after a bad interim phase without being punished, how to handle Kafkas when cooperation doesn't work, how to protect your identity across multiple professionals, how to stop being managed and start shaping outcomes, how to play the 6 to 18 month game, not the next hearing. This isn't a car crash course. It's operator training. There's another layer most people never teach, never reach, and that's where we're going next. We don't promise outcomes. We promise clarity and longevity. Court Ready in 30 Days teaches you how not to lose your case. The next phase teaches you how not to lose your future inside the system. That training is coming soon.